It's 1 minute before midnight, September 9th, 2020. I've looked very cursorily at 4 articles regarding this petition. Three of them have content that's pretty much the same, almost word for word. All three of them quote the same paragraph from the order from the court, but they selectively cite it. And there's another article I'm looking at right now that is slightly different. It discusses something very interesting regarding, it says here that, where is this? It discusses the amount of fees for members of the U.S. House, members for the Senate, and members for the Texas House, which, by the way, the numbers for the Texas Senate happen to be the same as a very important tax credit that I have been investigating for a long time. It was actually part of what I referenced in an article I sent to the auditor, the state auditor, in August of 2017 concerning a jobs report that had to be edited later because there was misinformation, and I had submitted a report to the state auditor of Texas, and have yet to hear back from them. So I just mentioned that because apparently this says is that there were some changes regarding filing fees made just last year. These are updates to the Texas laws I did not know about. But the fact that they got the Texas Senate fee for this particular tax credit is concerning to me. But even more concerning is this: 53 of 70 libertarian candidates paid theirs, state data shows. Now, there's certainly a concern about why 53 out of 70 would have paid their fees, unless this is misinformation. See, there was a change in the reporting because they had done something with the data regarding the number of children that were potentially exposed to risk associated with the COVID-19 announcements about back to school and the impact it had on young people and children. Specifically, I've put on my site, there was an acknowledgement about how they were pooling people from college along with people from high school or younger. And in that announcement, they had said that there were 70,000 children. They were going with this number of 70,000. And I remarked how uncertain things, but I didn't at the time remark on what the 70,000 difference was because the metric from before was 44,160. And I had done another video about my concerns around the fact that it was exactly 44,160. As a matter of fact, I did some computations online, like real time. Did they do something to try to peg it to a different risk factor with the 70 libertarians? Let me ask, was there any sort of consent to engage in this kind of litigious process by both Republicans and Libertarians as some sort of election hedging strategy that they had intended to use for some sort of long-term advantage up to and including potentially a nuclear paradigm? And insofar as there was an agreement, including an agreement to potentially allow oneself to be subjected to some sort of situation concerning frivolous litigation, what about the court? Now, if all of this is, I just found it on the Supreme Court of Texas website. It's on the official electronic filing site. I've got 4 articles that I've found very quickly. As I said, 3 of them sound like they are pretty much the same wording practically. This one's a little different and is written for around the time it was filed, the day it was filed. The other ones are later after the case had been denied. This one is around the time it was filed. But the situation is that the actual text of the order, I read through it, the actual text of the order says that there's a different standard for libertarian candidates than for the Republican candidates. The Republicans go through a particular process, but because the Libertarian Party selects its candidates by convention, then it's not required to go through the same kind of process regarding the filing of fees that the Republican Party candidates apparently had to go through. The specific code that's cited as part of the Texas Elections Code by the Republicans that are presenting the petition is addressed directly by the court, and the court says you cited this one specifically, and because this is the context under which you are bringing suit, it does not hold valid because that is not what they did. They did not go through this process. They went through another process that they had legal standing to go through. So you cannot challenge them under the process you're attempting to challenge them under, and hence your petition is denied. It didn't, the concept of the filing fees and to represent this as being about the filing of fees and the refusal to pay the filing fees is disingenuous. And say, if I hadn't read that part, I would be even more suspicious now with this metric situation concerning the fact that there are specific fees that they weren't paying, and that it allows for this calibration of a 17 out of 70 to be left as somehow being compliant, while there are 53 who did not. But even if there are 53 candidates who did not out of 70, why did they only choose 44? Why did they only choose 44 if this is accurate in that way? And the point of the matter is the petition says that the order said that there was no legal standing for the petition because the Libertarian Party went through a particular kind of convention process that has standing under another aspect of the Texas Elections Code, and what they were challenged under did not apply. It also says in these articles, however, that they've already done this to Green Party candidates as well, that throughout the country they've been trying to challenge Green Party candidates. And that, so the question then becomes one of, well, is there a comparable process going on in other parts of the country? They had said that Democrats had been challenging Green Party candidates to get them off the ballot. Did the Democrats do something comparable? Did the Democrats do something comparable this time, and is it comparable to things they've done in the past? Do they blacklist Green Party candidates using frivolous litigation, challenging their standing? Or is this a specific and select process they're going through now? We all know that I've already said that one of the reasons I haven't gone through the formal process at this time is because in many ways, given the way I would have proceeded, it's not even possible for me to go out and go to the places I would go as an independent candidate and obtain the petitions I would need on the petition in order to be able to register as somebody on the ballot to run for political office. They've changed the laws that would need to be in effect for me to be able to do a conventional campaigning process. There's no extraordinary process for petitioning to get on the ballot as an independent candidate. On the other hand, there is obviously this frivolous lawsuit against opposition political candidates. And what have we witnessed in the last month? Just the last few weeks. With opposition political candidates being imprisoned, being kidnapped, being poisoned, having to be taken out of the country for medical treatment. You can challenge all you want what the ulterior motives of that may be or what kind of political wrangling is going on there. But if in fact this is another example of local operators refusing to take responsibility for how significantly their gamesmanship ends up creating these moments of miscalculated leverage, this definitely needs to be intervened upon as soon as possible. Just so you know, I found this while I was looking to see if the Supreme Court of Texas had accepted a petition filed by the Attorney General of Texas's office, the alleged Attorney General of Texas's office, that had its own challenge to local election, to the Houston election situation with the distribution of ballots. So whatever's going on, Texas has certainly got its own fair share